So on Monday morning, I took a field trip to the Latah County Courthouse in Moscow, Idaho to watch Bryan Kohberger's arraignment and motion hearings. So now I'm going to tell you about what I saw. So it's about a 2-hour drive from where I am to Moscow, Idaho. So I did not go over the night before. I just got up really super early so I could leave and get there well before court started and nab myself a place in line. I went with my friend Heidi. Heidi is the artist who made my fish. She's also an amazing sketch artist. So this was going to be her trial run into doing courtroom sketching. I think she absolutely killed it. And hoping that she'll continue to join me on future outings to the courthouse because nobody has her style. Nobody can capture things the way that she does. We got to Moscow at about 6:30, and there were already people waiting outside, probably somewhere between a dozen and 20 waiting in line, nearly all press. They did seem to be pretty well organized. They had somebody who I later learned is a professor of journalism at University of Idaho that was kind of keeping track of who people were and what their places were in line and stuff like that. She wanted to know who I was with. I'm like, I'm a member of the public. And she looked at me strangely, but you know, hey, it is what it is. We did meet some other folks, not a whole lot of people that are just people from the public, but we met some folks who had come down from Spokane to watch the hearing, also a couple who had come up from Lewiston to watch it. So definitely public interest, but by and large, the overwhelming majority of the crowd was, of course, media. And so all kinds of different outlets, local outlets, national outlets, people from all over, camera setups everywhere. It was quite an experience for me, not, being part of that environment or really ever having experienced that before. I did get to meet Anjanette Levy from Law and Crime, which was super cool. I've known Anjanette on Twitter since, the Johnny Depp trial. So it's always kind of fun to, make those connections face to face. And yeah, great opportunity to sort of see up close and personal what the media does and how their job works. Kind of behind the scenes. The Latah County Courthouse itself is quite small. It's got the jail all the way at a far end, and then it's sort of this long building that has 3 courtrooms, and it's got a whole bunch of different county offices in it. The prosecutors there, the public defenders are there, the county auditor, county treasurer, all of those types of positions are all in the same place. You walk in the door and security is immediately to your left. They did a great job of getting, this mass crowd of people through. They did allow us to bring electronics into the courtroom and to use them. Of course, they needed to be on silent, but that I thought was a very nice gesture of them to allow us to live tweet if we wanted to. I didn't because I wanted to pay attention on what was happening. But at the same time, just having that option and that awareness that people are interested in the live updates and accommodating that, I thought was quite a nice gesture. Doesn't always happen that way. So Heidi and I were the very last people to make it into the main courtroom. Everybody else who couldn't fit into the main courtroom got sent into a secondary courtroom for overflow, where they just basically had the live feed playing into that room, and they watched it on a screen. A part of the reason for that is because one entire side of the courtroom was set aside for the victims' families. And so there was quite a large presence of, family and presumably friends and supporters, people who knew and cared about these victims and thought it was important to be there. So their presence is prioritized, and, that is certainly appropriate. But it meant that for our side of the courtroom, there was room for, maybe 100 or so people. If I were going to guess, I'd say there's maybe a total of 300 or so that were there for the hearing. So we were in the very, very back, most obstructed view, couldn't hardly see anything at all. In fact, the lady who had been organizing kind of keeping track of people's places in line and which outlets they were with and stuff like that. I found out later was a professor of journalism from University of Idaho. Did a very good job of keeping things organized, but had a little issue. Just as the hearing was starting to get started, she was trying to let somebody into the courtroom, but there's no more seats. So she asked me and Heidi if we would go into the other courtroom because there's media person here that needs to get in. It's media. I'm like, we're new media. Like, no, don't even try to play me like that. Like, come on, this is ridiculous. There's 98 other media people here in this room. So no, I did not give up my seat, but we did agree to scooch down so that the lady who turned out to be a reporter from the Lewiston Tribune, should have told me local news. I probably would have been a lot more friendly. Anyway, we made room for her to be able to come in and sit down with us, and that all worked out just fine. But so as a result of that, very likely that any of you who watched the stream from home probably had a much better view of really everybody, certainly Bryan Kohberger and Ann Taylor and their types of interactions. I just basically got glimpses as he came into the courtroom, and the rest of the time, of course, I'm seeing the backs of people's heads. But I did see something that I thought was remarkable, which was that the moment that Bryan Kohberger walked into the courtroom, his eyes immediately went to Ann Taylor. Just boom, that's who he looked for. And so that does tell me something. It tells me that they have a very good relationship. He trusts her. He is where she's looking for his security, his reassurance coming into this, It's not necessarily that strange of an environment, but it's a high pressure situation. He knows all the cameras are going to be there. That's his lifeline. That's where he looks. So I am not, expecting any sort of hubbub about conflicts or anything like that. Certainly at this point in time, things can change, but as it appears right now, it does look like they have a good working relationship. We got our first look at Judge, our first feel of him in the courtroom. He had a nice, fresh cut, looked sharp. A lot of the commentary that I saw in response to the arraignment, focused on the difficulty he had saying the victims' names, and that was definitely unfortunate. I felt for him. I could feel how uncomfortable he was. And, I did see after the fact, which some folks did report as well, that one of the victim's family members, I believe somebody identified her as Kaylee Consalvas' sister, was upset about the fact that the names had not been pronounced correctly. She thought that it was disrespectful, and I can certainly understand why she would feel that way. But for me, watching it from the outside, it looked like a situation where, I'm not going to say like, oh, he's got a learning disability or reading disability or something like that, but it looked like he just was having difficulty making that translation between words on the page to, sounds coming out of your mouth. So it certainly didn't look, hostile or uncaring or anything like that. It just literally looks like he's stumbling, trying to translate, what he's reading into a spoken word. And I'm sure that he was also feeling the pressure of the situation, the attention, knowing the cameras are there and all of that. It does change the dynamic in the courtroom as much as you want to think that they're just going to do things the way that they ordinarily do. The people are aware of them. And so there is a very difficult tendency to have to try to overcome, to not play to the cameras. So I do think that probably kind of elevated the anxiety a little bit for everybody, made it a little bit more challenging, especially in a courtroom like this where they are not going to be used to this type of attention. Contrary to some reports that I had read, it did not look at all to me like Bryan Kohberger has lost a bunch of weight in jail. He looks pretty much exactly like he did at his first appearance. He is simply a tall, thin guy. Didn't seem particularly nervous as well, seemed very well prepared. Another read that I got on the dynamic between him and Ann Taylor was how they went through the colloquy from the judge, where the judge reads reads the information, advises him of the nature of the charges, the maximum penalties for them, make sure that he understands, and then transition into asking him for the plea. And so that appeared to me like they both understood in advance clearly what was going to happen. They were on the same page, they had a plan, and they executed it. Bryan was clear and confident with his answers in response to, do you understand, the charges and so forth. And then when it was time to enter the plea, there was no need for double checking, conferring between them, double check to make sure what's going on. Nothing like that. Just immediately Ann Taylor, stands up and says he's going to stand silent. And so the court enters the not guilty plea for him. A lot of conversation that I've seen about this decision to stand silent. I don't really have a big read on it, honestly. It doesn't strike me as anything particularly extraordinary. And it's one of those things that it can sometimes be hard to tell what is just customary for a particular courtroom, for a particular attorney. People kind of have their ways and their preferences of doing things that, aren't necessarily right or wrong or whatever, but it's just how they choose to do it, how they see it as the right way to do it. So that's entirely possible that this is just kind of how Ann Taylor handles cases. She prefers to enter the not guilty plea for her clients. That is often my preference as well when I was doing trial practice. That's your job. You're there to represent them. You're there to advocate their positions. And so there's really nothing extraordinary, I guess, about taking that position. The standing silent derives from the Idaho Criminal Rule 11. It basically says if a defendant refuses to enter a plea, then the court will enter a not guilty plea for him. So is this Bryan Kohberger refusing to enter a plea? I mean, kind of, I guess. But what that rule is really getting at is a situation where you have somebody who is not cooperating with the process, right? They aren't respecting the authority of the court or the proceeding, so they're not going to play the game. They're not going to, be in the role that they're supposed to be in. So they just refuse to be difficult. And of course, that was clearly, from my perspective, not what was going on with Bryan Kohberger. This was just simply a decision that they made. He is not going to be the one to say not guilty 5 times in front of the victims' families, in front of the world. Whether that's just because that's a general preference, whether that was specific to this case because they didn't want him doing what could be, arguably seen as potentially kind of adversarial, in the victim's presence like that, to be asserting that he's not guilty, he didn't do it, he's not legally responsible, that can potentially be a little upsetting. So maybe a decision made to just keep the mood somewhat under control, keep things from inflaming the situation. And that's especially going to be the case, I think, if there are plea bargaining discussions going on, which I have to say there almost certainly are. Not because the case is guaranteed to end in a plea, not because Bryan Kohberger is certainly innocent or, certainly guilty or anything like that, but just because in a capital case, you have to. It's basically your responsibility to identify what are the possible options that your client has, because there are a lot of risk management decisions that have to be made in the course of handling a case like this. And so you would really be, irresponsible if you weren't seeking out from the prosecuting attorney, hey, what if we didn't fight it? What would you be willing to go for? Doesn't mean your client is going to take it, of course, doesn't mean you're not going to continue to assert your rights, but you do have to have those conversations and flesh out those options. So improving the situation for those negotiations to happen, certainly one possible explanation of that decision to stand silent. And of course, we saw that Bryan Kohberger did not waive his right to a speedy trial. He requested a trial date within the current limit. The limit was going to expire approximately November 22nd, so they set the trial date for October the 2nd. Now, this is what I personally expected, particularly after having waived the speedy preliminary hearing only to have the state convene the grand jury during that time and then, eliminate the need for having it in the first place. I'm not going to say that was like a strategic misstep or anything like that, but it is just something, that they're going to keep in mind, that the prosecutor, if they can improve their position, because you need more time to proceed, then they're certainly going to do that. So I see this as really Bryan kind of preserving his options to keep himself in the best possible position. If in October it looks like the state's not going to be ready to marshal its witnesses, marshal its evidence, then he may take a gamble, and decide to go forward. But I think it's far more likely that that's not going to be anywhere near enough time for the defense to be fully prepared. So there is going to be an opportunity in the future. If he decides he needs more time, he can move for a continuance. He can agree to waive his speedy trial at that time. So it's not like a do or die, something that he had to do at arraignment, or, it's going forward in October, period. The situation can certainly change. And my expectation is that it's very likely to. Another thing to bear in mind with that is that we are also seeing that there is discovery litigation happening. There's disputes about the timeliness of production, the scope of production, what's being produced, what's not being produced. And so maintaining that speedy trial limit and that trial date serves to put the pressure on the state to produce in a timely fashion. If there's not a trial date until, May of 2024, for example, it's just not as big a deal if the state sits on stuff for longer because, hey, if we give it to you in November, you're still going to have 6 months to be able to deal with it. So this kind of puts the pedal to the metal a little bit on some of those discovery issues and puts the state in a position because they have to diligently produce. They can be responsible for potentially misconduct, other dilatory behavior if they're not timely producing things, so that it puts the defense in a position where they can't reasonably prepare. If the defense could have been prepared had they gotten the discovery in a reasonable amount of time, then they have, a pretty good argument that this is the state's fault. The state is violating his speedy trial rights, and there could be a number of potential remedies for that. Unlikely to be as harsh as, dismissal. That can happen, but it's not likely to under these types of circumstances. But there can potentially be sanctions like, if you disclosed a witness late, you might not be able to call that witness, or evidence that, you just got from the lab. You may not be able to use that. If you produce that, right before trial, you had it and the defense hasn't had an opportunity to prepare for it, then a potential sanction for that is exclusion. So that is another strategic reason why it makes sense to maintain the current speedy trial deadline, get an early trial date, and then just play it by ear. As you're getting into August, September, see where you're at. You're probably not going to be prepared, but if that's the case, then go ahead and move for the continuance and waive speedy trial at that time. When it came time to the gag order hearings, the most noticeable thing was that nobody stuck around. The victims' families left, most of the press left, and the attorney generals who had been present at the state's table for the arraignment also left. And so I found that interesting. It indicates to me that, the AGs are not involved in this aspect of the litigation. That's something that the Latah County prosecutors are handling in-house. We saw, of course, Zoom issues. Get used to it with a small court, okay? These are not tech-heavy places. These are not your federal courthouses where they have, all of the newest and best and greatest technology. Yes, everybody got better during COVID because, we had to work on ways of having a remote court, but that's just not going to be something that is, regularly practiced and customary and normal in a small county, being able to use technology like this. I gotta tell you, really liking this. I'm not gonna say tirade. I don't want to like mischaracterize it, but Judge really dressed down the lawyer for the AP, and I was there for it. I haven't done a video on the gag order. I've just been meaning to forever. I've been so busy, haven't got to it. But I have read the briefing that went up to the Idaho Supreme Court and had my own impressions from it, as obviously did Judge. And so Judge called out the AP's lawyer for, you're misrepresenting the holding of the Idaho Supreme Court. Okay, we're not idiots here. We know how to read legal decisions. We know that what you said they held is not what they held. So you might want to like reconsider your approach on that. And then really taking them to task on their advocacy that the First Amendment is absolute. The First Amendment is not absolute by any stretch of the imagination. It's just not. So like, what a ridiculous position to argue to a court. He makes it clear he's got Sixth Amendment rights of Bryan Kohberger that he has to accommodate. And yeah, there is Supreme Court case law on that is pretty crystal clear. Sometime we'll do a breakdown of the big case on that one as well, so you can see how a media circus can cause major problems in a criminal trial, such that it's basically impossible for somebody to be treated fairly in a court process. So I liked seeing that advocacy personally. I am not a fan of gag orders. I'm not at all. Like, I'm all for transparency and stuff like that, but I just have to say the irresponsibility of the media in covering this case has just been mind-blowing to me. I'm going to talk a little bit about that in the future as well. So it's just, unfortunate that if the media isn't going to behave in a way that is responsible, that is going to consider the fact that this guy is entitled to his day in court and for stuff to be brought out and tested through the ordinary processes, then the judge is going to have to take steps. That's his responsibility. I'm glad that he appreciates that, and that it looks like he isn't going to be afraid of taking the steps he needs to take to make sure that happens. So then the court did set some future hearing dates. We know that on June 9th, they're going to address the gag order. He set a briefing schedule for that process. It's going to be interesting to see the briefing and whether the lawyer from the AP gets the hint, takes the message, and maybe revises his approach. I have to tell you, I called it a dressing down, and it was, but the other way to look at it is that this is being helpful, okay? Because when you take an extreme position in court, it's not helpful. Your primary job as an advocate is to be able to present your position in a way that is helpful to the court, that leads them to being able to see things your way and want to decide in your favor. And so when you take a position that, to my eye, frankly looks like a lot of grandstanding, that's not helpful to the court. You're not achieving your objective of being persuasive as an advocate. So the notable thing that I'll just mention about the gag order briefing from the AP is the lack of any acknowledgement of the Sixth Amendment right to a fair trial. I mean, obviously, these are things that have to be balanced. And if you're not taking that into consideration, you're just not going to be making a good argument for why a gag order should or shouldn't be in place, or what it should consist of, because you're just leaving out a huge piece of the picture that the judge is obligated to take into consideration. So that'll be interesting to see. Then on June the 27th, we'll have the hearing potentially on the discovery motions. The judge did not hear them on Monday. He set a schedule for them. And there were also comments that indicated, they're going to try to work through a lot of this this stuff. Typically with motions, when it's about something like late, you've had this, you haven't produced it yet, and the state's like, I'm trying, those things do happen. A lot of this stuff is not in the prosecutor's possession. He's got to go hunt it down from Pennsylvania. He's got to go hunt it down from, the lab, the FBI, like all these places. They all have a bunch of things that they want to do too. It's herding cats, okay? Discovery is not always a very easy or manageable process. We all get that. And so very common for a motion like this to be filed, mainly to kind of preserve your right and put them on notice, like, look, you need to start being a squeaky wheel and get some of this stuff. So it's very possible a lot of the things will be resolved before we get to that hearing. But there do appear to be some pretty fundamental differences of opinion that are going to need to be litigated, particularly with respect to the genetic genealogy. The state is clearly taking the position that they don't believe it should be disclosed, don't think that it's relevant. Defense obviously thinks it is. I can certainly see both sides on that. And I really want to see the argument from both of them for why it is or isn't, because that's going to tell us, presumably, a lot about the role that the genetic genealogy played in the investigation. When did it happen? How did it happen? Why did it happen? What role did it play in then setting up the chain of events that we saw laid out in the probable cause affidavit? So I am tentatively planning to be back in Moscow for the June 9th gag order hearing. I am very interested in seeing the evidentiary presentation that was referenced. Defense indicated that they had an expert that they wanted to present testimony from. So that is presumably going to be about the media coverage, what it's been, the reach that it's had, the scope of it, and the likely effect that it has on the jury pool and the potential damaging effect on Bryan Kohberger's right to a speedy trial. So I'm going to find that very interesting. I'm also kind of hoping that now that we've had cameras in the courtroom twice, that there won't be quite as much of the interest in being actually present in the courtroom for any of this. It won't be a situation where, if you're not there, you're not going to be able to report on it because you won't know what happened. And also just my suspicion is that a lot of the reason why there's so much interest in a hearing like the arraignment, which is from a legal standpoint exceedingly boring, but from a TV standpoint, it's very exciting because there's going to be words coming from Bryan Kohberger. You're going to hear his voice. He's going to speak. And that's much less likely to be the case for these other types of hearings, these motion hearings where it's just going to mainly be lawyers arguing. So Bryan Kohberger is likely to be there. He has a right to be present for those hearings, but there just really isn't a role for him to play in them. So he's probably going to be sitting there quietly observing, just like the rest of us. I'm going to play it by ear on the 27th and see if it looks like that's going to go forward. See how my schedule pans out as well. I'd already, kind of planned to be there for the preliminary hearing, so it shouldn't be an issue. But I'm just going to, see how that one unfolds, and if it looks like there is in fact going to be litigation on it as we get closer to that date. So as I've said throughout this video, I have so much to say about this case. There's also other stuff going on that I have a lot to talk about. There's been a lot of developments in the Marilyn Manson case, if you've been following that with me. So a lot of things. I'm going to do my best to get some videos out for you guys. In the meantime, it's Memorial Day weekend. It's beautiful. We live in the greatest era of human existence. We have the most privileged, luxurious life that, humans could ever imagine. So it's important to take time, I think, periodically to just appreciate that. So I hope you all have wonderful Memorial Day weekends. I look forward to getting some new videos out for you guys as soon as I can, and I hope you'll stick around. I will look forward to seeing you in the next one.